Okay, you can go ahead.
Hello and welcome. I'm Tony Ross, president of the Beverly Hills Bar Association. I wanted to be here today because as BHBA's president, but even more so as a member of the LGBTQ community, I wanted to emphasize the importance of today's topic. There is a fundamental shift that has happened on the US Supreme Court, and there have already been hugely momentous decisions handed down that changed decades or in some cases centuries of law. As we look ahead, it's possible this court will reverse recent gains, including one BHBA advocated for very publicly gay marriage or marriage equality. As a result, there's going to be a renewed focus on avenues other than the courts to address discrimination and inequities faced by our community. I look forward to hearing the perspectives of today's speakers on these issues, and I thank our litigation section for having the vision to put this panel together. Our family law, family formation, and inclusion sections, I thank for joining as co-sponsors. I'm going to keep my introductions very brief because I know you're all here to hear the speakers themselves. Their full bios are linked in the chat if you want to learn more. Amanda Goad is the Audrey Irmas Director of the LGBTQ Gender and Reproductive Justice Project at the ACLU of Southern California. She fights for the rights and civil liberties of LGBTQ people through litigation and policy advocacy. Among many other accolades, in 2015, she was named one of the 40 best LGBT lawyers under the age of 40 by the National LGBT Bar Association, and Amanda is a graduate of Harvard Law School. Welcome. Paul Smith has 4 decades of experience litigating a wide range of cases. He has argued before the US Supreme Court 21 times and secured numerous victories, including the landmark gay rights case, Lawrence v. Texas. He is the Senior Vice President of the Campaign Legal Center, a nonpartisan organization that focuses on voting rights and responsive democracy, and is also a professor at Georgetown Law. Paul is a graduate of Yale Law School and clerked for Justice Powell on the Supreme Court. Amira Hazenbush is a member of BHBA's Family Law Section's Executive Committee. Her practice provides legal assistance for assisted reproduction, adoption, co-parenting agreements, parentage orders, and guardianships, and also serves clients seeking name or gender changes. She is a member of numerous other professional organizations, including the National LGBT Bar Association. She has a JD and Master's in Public Health from UCLA, and I am delighted to now put the program in her capable hands. Amira?
Thank you very much, Tony, and thank you so much to my panelists for joining. It's an honor to moderate today. So just to give you a very brief overview of what we're going to be doing today, we're going to be looking at the Dobbs holding, doing a brief analysis of what happened there, and then really looking both at what exists in present time and what could happen in the future. It's really important to talk both about what potential rights could be lost and what rights are already at risk or are being lost as we are today. So we're going to be going through all of that. I encourage you all to put questions in the Q&A box. I will be going through all of the questions at the end, and we'll just go ahead and get started. So Paul, can you please start us off by giving us a big picture analysis of the Dobbs decision? What happened and what could it mean for LGBTQ folks?
Sure, Amira. Hi, everybody. Welcome. Hello from the East Coast, where I'm talking to you from. The Dobbs decision, obviously, as we all know, overruled Roe v. Wade and the Casey case, and held that there is no federal constitutional right to an abortion, that a state can regulate abortion as much as it wants to. Now, that was based on a particular approach to what is known as substantive due process. Where did the right to abortion come from that was in Roe v. Wade? Given that, as Justice Alito says in the opinion like 17 times, the word abortion is not mentioned in the Constitution, it was a right created and recognized by the court as one of the unenumerated rights, liberties that you have by virtue of being an American under the Constitution. And the concept has always been that we have some core liberties that the court will recognize, even though they're not mentioned in the Constitution, because they're part of the things that people should be able to decide for themselves, part of an insulated area of personal autonomy that the government shouldn't invade. What the Dobbs case held is that not that such a zone doesn't exist, that there is no such thing as personal autonomy, but that abortion is not part of it. And so they got there because all the justices agree that there are these unnamed liberties in the Constitution that have to be protected, but they disagree about how you identify them. And the conservative wing of the court has long been of the view that these unenumerated rights, these liberties that the Constitution protects, should be limited to things that have been deeply rooted in our history and traditions, things that have been rights you've had as Americans going back to the founding. That's the so-called Glucksberg principle. And the essence of the decision was that abortion is not deeply rooted in our history because it's been illegal for most of our history everywhere. And therefore it can't be a constitutional right starting in 1973. So what does that have to do with LGBTQ rights? Well, the reason everybody connects the two is that the core decisions that have created LGBT constitutional rights, written by Justice Kennedy, but primarily focusing on the Lawrence case that I argued in 2003 and the Obergefell marriage equality case in 2015, were, as Justice Kennedy chose to write them, based on a similar analysis, that there is a liberty to make choices about who you're going to have sexual intimacy with and how, that there is a liberty to decide who you're going to marry that is protected also under this substantive due process analysis. The risk is that under the conservatives' view of that, the so-called Glucksberg principle, they will come to the conclusion that those liberties also are not deeply rooted in American history, that there wasn't such a thing as marriage rights for same-sex couples until recently, that there wasn't such a thing as a right to make choices to engage in sex with a same-sex partner for much of our history. And therefore, we should overrule the analysis that Justice Kennedy put in Lawrence and in Obergefell. So that's what makes people realize that some of the disclaimers in the Dobbs case that Justice Alito put in, saying, oh, this has nothing to do with Lawrence, this has nothing to do with Obergefell, are kind of false promises, because once you follow the analysis that they followed, that only deeply rooted rights get protected, you do worry that we're going to end up in a place where those rights are no longer protected. Now, it's important to recognize, though, there is an alternative way for the court to continue to protect the right to make choices about sexual partners, about life partners, right to marry. And that is not a substantive due process analysis at all. It's an equal protection analysis. A different clause of the 14th Amendment guarantees equality. And that clause is not similarly burdened with this deeply rooted limitation. And it would be relatively straightforward for the court to do what a lot of people told the court it should do in Lawrence and in Obergefell, and say discriminating against people, same-sex couples, is violation of equal protection, that this is kind of discrimination that is especially troubling under the Constitution. And so there is, if the court ends up doing what people fear, if the court ends up deciding that after Dobbs, they're going to move toward overruling Lawrence, restore sodomy laws, move toward overruling Obergefell, and say people no longer have a right to marry if the state doesn't want to give it to them, that will be a choice that the conservatives have to make. They're not driven to that result by anything that's in the Dobbs opinion. They can uphold the results in those two cases under equal protection analysis. And I obviously, frankly, hope they will if the cases ever reach them, which hopefully they won't. I guess I'll stop there, Amira, and see whether we want to do some follow-ups.
Okay, great. Well, let's move to Amanda for a bit. And I know, Amanda, we talked about the difference between theoretical future losses of rights and current issues facing the community right now. Can you help tease that out a little more for us, please?
Sure. Thanks, Amira, and thanks to the Beverly Hills Bar and the co-sponsoring orgs for hosting this. I have been hearing all this discourse in the past few weeks about Dobbs is so horrible. What about Lawrence? What about Obergefell? What about Perry? And I feel that, and I want to be very clear that I share those concerns, but also sometimes get frustrated about whether that's the right conversation to be having. Because frankly, it can come across like privileged people concerned about a hypothetical risk of something additional that might go wrong several years down the road. when looking holistically at the state of LGBTQ affairs in the US right now, we have a lot of things going wrong right now. And at the risk of sounding like a serious Debbie Downer, I just want to put forth a few examples of what I mean by that. First of all, intersectionality is a thing, and there are those of us in the LGBTQ community who are feeling fully valued and economically succeeding and getting what we need, but there are a lot of folks who are not, often along lines of race, class, disability, other intersecting identities. There's data indicating that LGBTQ people writ large are about 3 times more likely to be unemployed and about 3 times more likely to be living in poverty than the general population. There's a stat I found particularly awful from 2015 from California, indicating that 36% of LGBTQ folks had been in clinically serious psychological distress within the past month. That's relative to about 5% of folks overall. LGBTQ people are disproportionately caught up in the criminal justice system because of both bias at every level of that system, and also the ways that if you're experiencing other discrimination and marginalization and you get pushed out of traditional economic opportunities, you get forced into survival economies, and most of those are illegal. Once caught up in the criminal justice system, LGBTQ people tend to have an especially awful experience, and prisons are gendered institutions, so they are rough for those of us who don't cleanly fit the gender binary. A lot of my recent work has been around that. Bisexual people, in addition to trans people, are a subset of the LGBTQ community who have things really rough in terms of poverty rates and violence rates. And on the violence front, I think people often are aware that there is an epidemic of really serious violence against the trans community, particularly trans women of color. But it's not just trans women of color, and it's not just the sort of shadowy was or wasn't this person engaged in sex work kind of narrative that comes up. I've had a friend who is a white trans woman, also Harvard Law educated, tell me recently she stopped taking public transit because of the death threats. And I just think that there's a vast disconnect between perceptions of how the LGBT community is doing in sort of a global sense. When yes, we have had all these fantastic legal victories, as Paul recapped, and those are significant, and it is worth celebrating all that progress in the course of my lifetime. But on the other hand, there is so much yet to be done. And if we care about really lifting up the whole community, there is a lot of work that needs to happen that isn't really going to be done through a Supreme Court decision anyway. And in 2022 in particular, we've seen so much happen in the political and legal landscape that is hostile to LGBTQ folks and our community's interests. You know, I think one could make an argument that those efforts are coming out of a similar political source as what resulted in the Dobbs opinion, but they are also a distinct front on which we are fighting to maintain the rights and dignity of our community. So I hope that folks are not so concerned about a hypothetical risk to marriage equality or intimacy rights or anything else that they lose sight of the legislative and other kinds of state-based attacks that have been ramping up so horribly this year and really causing people a lot of harm. And I guess one more piece of negativity or concern to throw in there is that we can have important conversations about what Dobbs means for the LGBTQ community in the sense of other rights that it may indicate are also endangered down the line. But I don't want to lose sight of the significance of Dobbs as a problem in terms of abortion rights for the LGBTQ community. The loss of abortion rights in so many states is a public health emergency at a national level, whether the federal government chooses to declare that or not. Within that, it's an LGBTQ emergency. I think we're starting to finally acknowledge that there are trans and non-binary folks as well as women who need abortion care. There are also a lot of queer women who need abortion care. And I don't think most folks understand that not only bisexual women, but lesbian women are more likely than straight women to report that they have experienced an unintended pregnancy and more likely to have had an abortion. So this loss of rights on the abortion front alone, which is real and tangible already, that is an LGBTQ issue, and I think we need to treat it as such.
Absolutely, thank you. I'm going to come back to Paul for a minute and ask, this is to maybe uplift us a little bit and talk about what can be done. What is it that we can be doing at this point to, address this, considering the current constitution of the court?
Well, I think the one thing I would say is, and I don't disagree with Amanda at all, that we don't want to lose sight of the ongoing day-to-day challenges, is to suggest that we can fight on all these fronts, that there is enough capacity in the movement and in our community to do everything we can to forestall future losses, while at the same time not for a second minimizing our concerns about what has really become really a campaign of harassment of certain elements of our community. What really happened here after 2015 with marriage equality is the opponents of LGBTQ plus equality were looking for ways to fight, and they fastened on religious accommodations, exemptions, and attacks on the transgender community as a more vulnerable community politically. And that has, both of those two fronts have continued all for the next 7 years. And if anything, are ramping up. And so we have all of these state laws being passed about minors in healthcare, trans people in athletics, child abuse allegations being levied against parents of transgender youth, plus this constant effort to push back the line where more and more businesses have a constitutional right to discriminate, either under the free speech clause or under the free exercise clause. The case this coming year in the Supreme Court about a website designer is going to be based on the free speech clause, and it seems pretty likely that the court is going to flat out say that a person in an expressive business like creating websites does not have to serve, this is wedding websites theoretically, does not have to serve same-sex couples if she doesn't want to, and that you can't force people to engage in, to compel them into engage in artistic expression. So those two fronts that were started, even before 2015, but really have kept going, are really active, and even leaving aside all the economic disparities that Amanda so accurately described and the criminal justice disparities. But there's also, I don't think people should think that this is a fight we cannot win. First of all, the American people are on our side. The reason why the religious conservatives who are the opponents of LGBTQ equality have fastened on trans people is because they understand that they politically attacking gay men, lesbians, bisexuals is a loser for them. The American people now support marriage equality by over 70-30, and that percentage is continuing to go up every year. And I don't actually think we ought to assume that even the current Supreme Court that we have wants to take the step of applying Dobbs to take out the right of people to make choices about who they want to form a family with, both in terms of sexual intimacy and in terms of legal marriage. For them to do that would be, I think, a disaster with respect to the court's perceived legitimacy on the part of much of the American people, the large majority of the American people, particularly younger people. And that is a huge mistake. Some of them will want to do it, clearly, but I don't know that they have 5 votes. And as I say, they have a doctrinal way out. And so one thing we should do, even as we fight all these other fights, is try to make it as difficult as possible for the court to take that step. And, that can be done by a mounting campaign of support for all forms of LGBTQ equality in the press, in people's legal rhetoric. This is a message that needs to be sent, that this is the line they shouldn't cross, they can't cross, they don't have to cross. And, if they start to do that, of course, then there will be a political firestorm of quite remarkable proportions. So this is an ongoing fight, and I think we have a lot of weapons on our side, so people should not lose heart.
Absolutely. Do you think either of you could talk a little bit more? I know we've been trying to pass the Federal Equality Act for many, many years, and it feels like a uphill battle might be a gentle way of putting it. So if you can talk a little bit about federal legislation and regulations and where we think there is room or not room for change there. I'll throw that out to both of you.
I can take a crack at that. Like you said, Amira, the Federal Equality Act has been proposed for a long, long time. It's really a descendant of previous bills, some version of which has been introduced in every Congress since before I was born in the 1970s. And folks have put a great deal of work into refining it into what we know today as the Equality Act, which would be comprehensive and put explicit sexual orientation, gender identity, gender expression protections into statute in a variety of contexts. Full disclosure, I was briefly part of the drafting team for the 2013 version of the Equality Act. But we've been trying that tactic for a really long time. And the Equality Act honestly seems to me to be on a list of bills that enjoy broad public support, but are not going to pass the current Congress. And we could have a whole other conversation about why that is and what pathways might be to change that political dynamic. But I personally don't want to rely on that as a strategy when, first of all, it doesn't seem like it's getting traction at the level that would be required to actually become law. And secondly, it would not solve all of our problems. Everything in the Equality Act pretty much is already California law, and I was just reciting some of the ways in which we are not enjoying full lived equality for our community in California, for example. And then I want to hear Paul's take on this well, but just to briefly touch on the regulations piece, regulations fleshing out statutory protections have been an important way that the current administration and the Obama administration and some others have tried to extend protections in a little more specific and granular way to the LGBTQ community than what was in federal statute. But we've also seen a lot of litigation brought to challenge that and try to chip away at those protections. And the chances that that type of challenge succeed seem to be rising because of additional negative developments out of the Supreme Court. After Dobbs, they released an opinion in West Virginia versus EPA, which was obviously an environmental case, but it touched on the structural dynamic between branches of government. And it could have been worse, frankly, but where it came out indicated that this court is quite willing to say that an agency with relevant technical expertise has gone too far, particularly if, what they did is not the result this court would like to see occur. And that will mean a much greater likelihood that bold progressive regulatory moves get struck down as exceeding the authority of the executive branch. And that makes me nervous about how far that tactic is really going to be able to go.
Let me, as the one who tries to inject the occasional optimistic note into this conversation, Amanda, remind everyone that the effort to make regulatory progress is built on a foundation laid by the Supreme Court itself just 2 years ago in the Bostock case. The Bostock case was a remarkable actual step forward in lieu of passing the Equality Act. What that decision said was that one important federal anti-discrimination statute, Title VII, which obviously prohibits discrimination in the private sector employment world as well as public sector, including discrimination based on sex, prohibits any form of discrimination based on gender identity and sexual orientation, because those are in fact always discrimination based on sex. And this was an achievement of really quite remarkable proportions, of almost, you could say, as important as Obergefell itself, in the amount of additional legal protection accorded to vulnerable people all over the country, all 50 states, by virtue of an opinion written by Justice Gorsuch and joined by Chief Justice Roberts. And their basic reasoning was sex. You can't just talk about discriminating against somebody because of their orientation or their fact that they're transgender without talking about sex in a way that makes it illegal. And that is the foundation then that the Biden people have been using to try to extend things into, for example, Title IX regulations and the like. Try to extend bathroom protections in the public schools and things like that to transgender students. And that will get fought out, but I think the reason I mentioned Bostock is in part because itself is part of our overall picture, a remarkable advance that is still paying dividends on a daily basis all over the country to people who would otherwise have no rights at all from discrimination. But it also provides the roadmap if the Supreme Court decides they want to affirm marriage equality, affirm Lawrence on a different ground, not on substantive due process, but on equal protection grounds, because it is at least one of the ways in which you can apply the Equal Protection Clause to say that discrimination against same-sex couples is a form of discrimination under equal protection that needs heightened scrutiny, careful review that we're not going to allow the government to engage in, either in denying marriage licenses or in regulating people's sexual intimacy in a way that we don't regulate straight people. So, those are the tools we have available, both in the regulatory front in Washington that the Biden administration are using, and in the private workplaces all over the country. But it also provides a way in which an analysis of equality in the LGBTQ context, one adopted by Gorsuch and Roberts, is available for imitation and application in the constitutional context if we get up there with a marriage equality case anytime soon, and we may very well. So I think it's important to have that balanced picture that there are things that we can say give us hope as well as despair.
Absolutely. And you explain this, but I think maybe for people who aren't entrenched in it all the time, it might have been a little bit high level. So I'm going to ask you to go into just a little bit more detail about rational basis with bite and intermediate protection, all of those different levels of scrutiny under equal protection, and how a statutory interpretation case like Bostock could actually ratchet up those levels in an equal protection case. Because I think you for sure. Those of us who aren't thinking about it all the time,
people don't practice constitutional law on a daily basis. Amazing. So those of you who will remember that in law school you studied equal protection clause, and obviously not every classification in the law is unconstitutional. When the law says you could put people in, you give them tickets for driving over the speed limit but not under the speed limit, that's a perfectly okay rational classification that doesn't require any special scrutiny. But the way that the law has evolved is that the court has identified particular classifications in the law that are particularly suspect. The most obvious one is a form of racial discrimination, the segregation of the public schools or the exclusion of people of a given race from serving on a jury. That gets the highest form of scrutiny, strict scrutiny under the Equal Protection Clause. And then there are categories which are in the intermediate level, and the great achievement of RBG was to achieve the heightened review of laws that are discriminatory based on sex. And so those laws are generally unconstitutional as well, although maybe not quite as automatically as racist laws that discriminate based on race. And so what's that relevant to? Well, because the Bostock rationale was that sexual orientation discrimination is sex discrimination, then if you would follow that analogy, then sexual orientation discrimination should get the same form of heightened intermediate scrutiny, be presumptively unconstitutional under the Equal Protection Clause, including the denial of marriage licenses on an equal basis to couples because they are of the same sex as opposed to a different sex. And so that's why we view Bostock as an optimistic sign. There are other ways you can get heightened scrutiny under equal protection, and one is to just look at factors the court has looked at. And as a number of courts have held, leaving aside the analogy to sex discrimination, discriminating people against LGBTQ people is one of the classic forms of things that ought to be protected against in a heightened way. There's a long history of discrimination against this group. This is not a group that has the capacity to protect itself politically. These are not characteristics that affect your ability to contribute to society. And these are the factors that the court has said ought to identify those characteristics which you can't use as a basis for discrimination in the law. And so you can get there that way, or you get there through the sex discrimination route. But there is good reason to think that if the court took the issue of marriage equality and looked at it from the point of view of equal protection, that 5 justices might well conclude that they can't simply apply the most minimal level of scrutiny, which is rational basis, that they have to apply a more muscular scrutiny. And it doesn't take much more muscle to your scrutiny to win the case for marriage equality. One of the problems that the advocates of discrimination in this area for the last 20 years always had was there is no state interest that anybody can articulate why a state refuses to give a marriage license to same-sex couples. What interest does it serve? And once you get into intermediate scrutiny under equal protection, you have to come up with a state interest, and then they have to show that it's a really important state interest and it can't be served in some less restrictive way. But they can't even articulate a state interest. One of the great things that the Lawrence case did way back in 2003 is say the one thing you can't use to justify discriminating against people for being gay or lesbian is moral disapprobation, that somehow the government believes your relationships are more immoral than other people's relationship. What Lawrence held was the government doesn't get to have a point of view about who you choose to move in with and have sex with. That's your choice in life. Nobody should have to go down to the government to get permission to form a familial relationship or a sexual relationship for that matter. And once you take morality off the table, they struggled for years and years and years to come up with some reason why they wouldn't give the same marriage license to same-sex couples. And there really isn't any answer to that question. They'd have to go back and actually allow the government to have a moral view, but that seems quite unlikely. So, those are whether the court will actually, be as open as I hope it will be to these arguments, I don't know, but it sure should be.
Yeah, and if you want to find a really interesting sort of recitation of that argument of what are, why were states trying to prevent marriage equality, Kenji Yoshino wrote a book called Marriage Equality on Trial. The title is Speak Now, and he read every single transcript and just did a beautiful sort of reenactment of it into a smaller book form that's really fascinating and great to
even the lawyer for the bad guys in the Perry case in California, who was when asked what is the state's interest in not marrying these people, couldn't come up with anything. There is no answer to this question. So.
Right. Absolutely. And so since we're on the topic of equal protection, there's a question in the Q&A that I think is really appropriate to discuss right now. It says, equal protection won't save Griswold. What will if the court veers even further to the extreme right?
That is a good point in that the court tends to resist any argument under equal protection for a liberty that even just on the theory that it's got some sex-based aspects to it, like abortion or birth control, contraception. And so, I don't know as much about this as a lot of other people probably, but it would strike me that what will save the right of access to contraception is that no state's going to meaningfully prevent it. There are some targeted contraceptives that the religious right has singled out and say, no, these are bad ones. They're sort of a little too like abortion. They're the ones that were targeted in Hobby Lobby, but they're not going to ban condoms, I don't think. It seems very unlikely that this is going to be the world we live in. In 1965, when the Griswold case was decided, Connecticut was the only state in the country that had such a law, and it hadn't enforced it in 30 or 40 years. So, it is, maybe things have gone so completely crazy on the religious right that they're going to start trying to ban the pill, but I would be surprised. Amanda, do you have a view about that? Am I completely or Amira for that matter?
Well, we are definitely in the land of hypothetical speculation right now.
Yes.
And I am uncomfortable saying confidently that this court won't, or that some of the states in the interior West as well as the South won't take actions that are really devastatingly harmful. We don't necessarily know where those parameters are. I think taking a bit of a step back, this court, as Paul alluded to a little earlier, does seem to care about the interests of corporate America and the interests of certain folks in power, even if it doesn't necessarily care as much as the court as an institution used to about public opinion writ large and how it is coming across as an institution. So there is part of me that feels a certain degree of confidence that a core holding like Griswold on the basic principle of contraception might be in less danger than some things that are currently under direct legal threat, because people of all walks of life, including wealthy white property owners, use contraception and are open about it. And that is different from some of the other stuff on the table. I think it will be really harmful and destructive to people and their families if access is lost even to specific means of FDA-approved contraception. And I don't think we should, make too much light of that. But that's a little bit of a different question from whether access to contraception at all will go away. And
so the other thing, I'm sorry, go ahead.
Go ahead.
I was going to say, the other thing I would mention, since you mentioned corporations, is that one of the weapons that we have, if particular states start going really crazy, is corporate America. And the corporations, whatever else you say about them, tend to try to maintain some respect for the interests of their own employees, if only because they want to keep those employees and they want to hire new ones. And so a state in which that level of interference with personal liberty over something as core as basic FDA-approved contraception is getting involved in that might very well find itself subject to all kinds of boycotts and corporations moving away and all kinds of stuff. This has already been a very effective weapon in some of the other wars we've been fighting for the last 6 or 7 years, involving bathroom bills and the like. And so, again, a part of the fight that we should not neglect.
So let's talk about that issue of sort of cross-jurisdictional, because I know we wanted to talk a little bit about full faith and credit. We're seeing now corporations saying, well, we'll protect our employees to go other places if they need to. I mean, again, we are getting into the theoretical here, but if we see a possible striking down of marriage and sending it back to the states, how do you see that playing out in the future? What could that potentially look like?
Well, there will be many, many states in that world that continue to be places where same-sex couples can get married. There will be some that will not. The first thing I would say is I think it's extremely unlikely that any state would even try to unmarry people on the theory that we were forced to marry you by an erroneous court decision back in 2015. This court, I think, would not stand for that for a minute. And, call me overly optimistic, but that's just a prospect of so extreme a nature that I don't see that happening. But some states will stop marrying people and will probably refuse to recognize same-sex marriages of same-sex couples from other states as well. And that's where, you start to see a messy situation start to develop. And if the court has held already that there's no right at all there's nothing unconstitutional about states refusing to marry same-sex couples going forward, then I guess they probably can also refuse to recognize marriages from other states. Marriage has never been subject to the full faith and credit clause. It's not a judgment, and I think that, you know, maybe people can make that argument more effectively than it's made in the past, but there's a long history of states refusing to recognize marriages from other states when people are first cousins, or people who are one of the two people involved is too young. And the courts have generally upheld the ability of states to have public policy objections to marriages of that kind from other states. And so that's a daunting prospect for sure.
And I do want to take a little bit of moderator's privilege on here, because I know I was asked to talk a little bit about the family formation aspect of this and protecting our families. So as Paul mentioned, full faith and credit clause was never required to uphold marriages. It was Obergefell that suddenly gave every state the requirement that marriages from one state had to be recognized in another state. But marriage equality didn't give us a parentage equality. So in the same way that a marriage certificate previously did not have to be recognized, a birth certificate, even to this day, does not need to be recognized from state to state. And so it is really, really important that people get those judgments protecting their parentage. So I and many other lawyers throughout the country help people to get confirmatory adoptions or step-parent adoptions or second-parent adoptions or parentage judgments, some judgment from a court that's entitled to full faith and credit that protects parents across state lines. So if you get anything out of this from my perspective, I hope that you will tell your friends who say, but we're both on the birth certificate, to say that's not enough. Please, please, please go get a judgment that protects you. And I do have a colleague who has an idea of getting a marriage judgment that suddenly that should be the next thing.
There is a distinction. Adoptions are judgments that have traditionally been respected across the country for that reason, because of the federal full faith and credit clause.
Right. And we even have a Supreme Court decision upholding a same-sex adoption, you know, even with, there was a per curiam with Scalia on there. So I think we're in good shape, but get those judgments. The birth certificate is not a judgment. So let's, Amanda, do you have something you wanted to add?
Actually, yes, it's tangential to this, but while we're on practicalities, I just wanted to lift up the part of what Paul said about how even in a worst case scenario where rights are being eroded, we can be pretty confident that there will continue to be a lot of jurisdictions where marriage availability is not a problem. And on that note, you know, there are a few different ways that a bad development could happen on marriage equality, but a likely one, in my view, is a clerk or some other government official tasked with issuing marriage licenses refusing to do so. We saw a tiny bit of stuff like that in the previous round of marriage equality wars with Ken Davis in Kentucky and so forth. And I would not be surprised if either sua sponte or perhaps put up to it by ADF, Liberty Counsel, et cetera, we started to see clerks in red states, blue states, hard to say, not fulfilling their duties in that way. And I am a little bit concerned that folks who get into a situation like that and are indignant about the violation of their rights and perceive this as blatantly unconstitutional, which it is, might rush to court. And there was a time when that was a move that helped bring about positive change for the LGBTQ community, but right now there is a growing risk that that would in fact lead to a structural setback for the LGBTQ community. And I hate saying it, but I think it's worth noting that in that scenario where someone is denied a license, there are going to be other places they could get it. And of course, traveling to get it is not easy for some families, but this may be a thing where the helpful move is not helping someone sue to challenge the discrimination, but mutual aid to help them get what they need somewhere else.
Right. Although there were arguments about that before marriage equality cases as to whether or not to bring those cases and whether we would end up with a Supreme Court case reaffirming the lack of marriage equality. So
for sure,
we will, unfortunately, everyone has access to the courts and there is no way to control who ends up there. But fortunately and unfortunately, right? We all have access to the courts.
So far, anyway.
Yeah, to be determined. But I think what we're touching on here is also a lot of religious implications, right? There's going to be a lot of crossover. So how do the court's recent decisions on issues of religion play into what we can expect to see on LGBTQ rights cases moving forward?
Well, the court has obviously been very solicitous of religious arguments that they should not be forced to do business with people whose lifestyles they find to be problematic as a matter of religion. And, this is Masterpiece Cake Shop. This is the Fulton case out of Philadelphia. And, these cases are being litigated aggressively by the ADF. And they go on both free speech and freedom of religion grounds. Whether the court will ultimately go just on speech grounds, and if so, will it limit this just to businesses that have kind of an expressive aspect is hard to say. My guess is that this will continue to enlarge this idea that you have a constitutional right to disregard state anti-discrimination laws or even federal anti-discrimination laws now that Title VII has been extended to sexual orientation. I think that will continue to grow because there's clearly a majority of the justices who believe that the victims in our world right now are conservative religious people. And that they should do everything they can to protect them from being treated badly by virtue of their beliefs, including their anti-gay beliefs. So we're going to have more movement in that direction next term in the 303 creative website case, the wedding website developer. She's going to win, I think. And that's just, but that's a piece of the story. In many ways, the more severe stuff that's going on right now, that's already happening, is what's happening to the trans community. And so I don't think we should forget about that. The idea that people are being subjected to rules about whether they can get the appropriate medical care that their doctor has prescribed is so scandalous, it seems to me, and it's so dangerous because of the suicide rate in this population. And you're talking here about adolescent populations of people just struggling to get by, and it is a very, very problematic and irresponsible thing that is happening around the country in this area. So I just wanted to bring us back to that and make sure we remember it.
Absolutely. Paul just said the majority of what I wanted to say, but I guess I would add into the mix in terms of reasons to not feel confident about where the next few cases about the quote unquote balance of free exercise of religion with other interests are going to land. Not only have there been bad substantive holdings in cases like Fulton and like Carson from this past term about the Establishment Clause and taxpayers funding religious education in Maine, most recently Coach Kennedy out of Washington State and prayer at a football game. But there's also this move by the current court toward playing fast and loose with the facts of what happened, which was very much an issue in the Kennedy case, was Justice Sotomayor's dissent, including photos of what it really looked like on the football field to illustrate that that was not a private prayer, as well as playing fast and loose with the procedural state of the cases in order to grant cert in situations where they have a particular result in mind, which is very much an issue in 303 Creative. I don't even want to call that plaintiff a wedding website developer because she's never actually done a wedding website. This is purely hypothetical, and I don't think she has standing, which was also an issue in West Virginia versus EPA and a number of other cases this past term. So it's like we have a convergence of an activist court that is comfortable with issuing really conservative rulings, but also activist in more of a meta sense of willingness to pull out exactly what it wants to address and do so in the way it feels like without nearly as much adherence to procedural norms as we used to see.
Yeah, there's no question that the court is really activist on steroids right now and feeling like they have this time, maybe only a limited time, and they're going to do everything they can to achieve conservative nirvana. The thing that drives me crazy in my work these days is primarily in the area of trying to protect American democracy from the threats it faces, which, as you can imagine, is a fairly busy area of practice right now. And you look at their work in that area, and it's really, really aggressively anti-democratic. They're a problem. They're not part of the solution. And then you look at Dobbs, and he says, well, but we're just going to return this to Kavanaugh's concurrence. We're just returning this to the political decision makers, and people can vote for whoever they want, and they will, the majority will rule. But but once they start distorting the democracy on top of it, then that argument really rings false. And so it is a time when we need to push back every which way we can against a court that is really feeling its oats.
Absolutely. And with all these changes, do you foresee changes to the structure of the Supreme Court in the near future as a result of this extreme conservative bias? Would you advocate for any of those changes?
You want to do that one, Amanda, or you want the problem with fixing the Supreme Court through court reform is it's very difficult. And, certainly if you have, to the extent you have to amend the Constitution, that's essentially impossible. The one change that is, clearly constitutional and can be done just by federal statute is adding justices. Some people think you could do term limits by statute. I've always wondered why that could possibly be constitutional, but some people do make that argument. None of this is happening now. We have the same 50-50 Senate that prevents passing democracy reform, that prevents passing the Equality Act. They're not going to pass anything like that. But it's an imaginable future over the next 5 years if the court continues to be as absolutely aggressive as it has been, and I think it will. Next term is going to be even more crazy than this one. Affirmative action, voting rights, oh my God, that there might be a political backlash that gives the Democrats more seats in the Senate and a political will to take this problem on. It has happened in the distant past that the court, Congress has changed the number of justices. It's perfectly within its power to do that. They can't get rid of existing justices, but they can add justices. And so, it's not very likely, but it's certainly possible to imagine a scenario under which we get to that extreme level of upset with the court.
I would lift up a statement issued by colleagues at other LGBTQ advocacy organizations, Lambda Legal, Transgender Law Center, MCLR, and GLAAD, calling for court reform, including adding 4 more seats to the Supreme Court and also imposing a binding ethics code on the Supreme Court, among other things. But I very much share Paul's concern about whether anything of that nature is politically viable.
So what we're seeing in some respects here is sort of these extreme pendulum swings, right? We saw suddenly like a lot of equality and a lot of protections, and now we're going back in the other direction. Do either of you feel like there's a possibility, even with, we talked about this could potentially switch who's voting for what? Do we feel like there's a possibility that things could be going back anytime soon? Or is this because of the structure of the court itself kind of here to stay for the next 30 to 40 years?
Oh, no, you can't suggest that the court is stuck in a particular ideological place for 40 years. I mean, the court does change. And if the Democrats continue to occupy the White House for a while, and I'm not suggesting that may or may not happen, eventually there will be a change in the personnel of the court. The Democrats have been extraordinarily unlucky in losing the presidency twice in the last 20 years to people who didn't win the popular vote. That was Bush 2 and Trump. But eventually, if they keep winning, Justice Thomas isn't going to last forever. Justice Alito is not going to last forever. There will be a change back, and it doesn't take 30 years. There will be a lot of damage in the meantime, that's for sure. But I do think that the political branches can have an impact. Both Congress can pass things, and just electing more progressive presidents can affect the court over time.
And we have a question from someone who says, doesn't adding justices just lead to a situation where every time a new party gets in control, it increases the number of justices? When would it stop?
I should be clear that the ACLU does not officially support this form of reform for that reason. And I think David Cole had an op-ed out recently, our national legal director, articulating that.
Yeah, that's the concern. So that's why it's an extreme measure which you should only take if you think that the court is just completely rogue. At some point, I think that the argument for disregarding that is powerful enough, then you just do it. But it's not, we're not there yet. That's why I think David Cole has a point. At this point, we don't want to necessarily go down that road, because it not only leads to a tit for tat, but it further undermines any respect for the court as a legal institution, makes everybody just think, well, it's just another branch of the Congress, essentially, political everybody's voting their party. And, we're getting there already, admittedly, but that would make it worse.
And I guess just to go back to my negative litany from earlier in this conversation, I think a lot of what we need is not going to come from the Supreme Court anyway. And I think it's important to continue thinking about things like public investment in services that are actually helpful to address communities in the LGBTQ realm and beyond, housing, education, mental health treatment, those sorts of things. And, litigation is important. Impact cases will continue to be a potential strategy for change, but budget advocacy is what we need to fix some of our challenges.
Absolutely. So we are actually at the end of our questions. So I'm going to ask two final questions from the two of you, and you can pick which ones you want. One is my personal one that I've been dying to talk about, and the other is just sort of a closing question. So my personal question is, if you do a very deep read of Bostock, what you'll notice is that the word homosexuality is used, but there is never a mention of bisexuality, that transgender is discussed, but never non-binary. And I think that there's this in-between space that is completely erased in the case. And I wonder if you have predictions as to what that could lead to in the future. And then our general closing question will just be, aside from vote, which hopefully everybody who's attending this knows to do, is there anything else that you could suggest our attendees do if they feel like they want to make a difference in what's going on right
now? Amanda? No?
Oh gosh, that was a lot for
Sorry.
4 minutes, Amira.
4 minutes,
go. To the first, I am really curious about who will be bold enough to try to bring a non-binary issue before this court. I am not excited to be the one. And to the second, I was just talking about resourcing, and I think that's what I would say in terms of constructively, what can we do? I think that's a matter of both public investment and private investment to get through these dark times. On the public investment side, as you vote and donate and otherwise personally engage in the political process, pay attention to where folks want to devote public resources, and is it toward the kinds of supports I was just talking about for marginalized communities, or is it toward expanding the police and otherwise maintaining the harmful status quo? And then private investment should not be what we rely on, but it's a resource that we have. And for folks who have the ability to donate to grassroots organizations and support the most marginalized members of the LGBTQ community and others in these rough times, particularly in parts of the country where things are especially rough, it's worth doing.
I would just say that on the first question, non-binary, bisexual, the logic of Bostock would seem to apply fully to those claims as well. If somebody is discriminated against, because I don't mind having LG people, but I don't want any Bs around here, that is, again, discriminating against them because they have relationships with both sexes. That's the same problem. So that doesn't necessarily mean, as Amanda suggested, that Justice Gorsuch will follow his own logic when he gets there, but that would seem not to be a very difficult argument to formulate, even if somebody is perhaps foolhardy enough to try to go up to the court with that claim right now. On the what else can people do? I agree with Amanda that there's a lot of what you can do is getting involved in organizations that are doing all kinds of different important stuff in the community. One category of organization that's really valuable, I think, are those that work to help and support vulnerable LGBTQ youth. And I'm sure there's one in LA. There's certainly, most cities have them. These are people who end up in just terrible personal circumstances because they're rejected by their families, or they're getting abused in some way, or they're getting bullied at school, or all three at the same time. And such organizations, for a relatively modest investment of resources, can make an enormous difference to the life chances of that very vulnerable group of people. A group of people that are the reason why the LGBTQ community is so overrepresented in things like juvenile detention facilities and the like, because of their economic vulnerability created by family rejection and other things. But there's so much that can be done in that area just by getting involved and reaching out and providing some relatively modest